church. Sir, you need to take off your hat. Good morning. The end of the world has not happened.
Oh, it will, Judge.
Yeah.
It will.
Wait, yellow shirt, where? Oh, is he sitting behind the attorney?
Yes.
Okay, because I was like, is my sight really that bad? I don't see it. Okay. All right, so what's his name?
Abel Martinez?
Done, Your Honor.
Zach Dunn, like 9. All right. You say Martinez?
You said Abel?
All right, Abel Martinez, how old are you? 21? Shorts are not allowed in the courtroom. You understand? So next time you come to court, do not wear any shorts. You understand?
Judge, Mr. Martinez here for a master, I believe.
All right. All right, everyone. So today is Friday's Eve. Is it going to be a difficult Friday? Difficult Friday's Eve? I don't know. But I'm putting that out in the universe because, did I just jinx us? I'm sorry. So they changed over to the system called Odyssey. My understanding, the rumor is that the person who put the system together is somewhere in Hawaii enjoying the fact that they put a system together and now they don't have to work anymore. So maybe the system's going to work. Maybe it's not going to work. All I know is there are certain systems that people don't have access to anymore that they didn't have before. So for the young people, we're probably going to do it Flintstone style. They don't know what that means because they haven't watched the Flintstone. So we're probably going to be old school, writing on paper, whatever, doing motions, filling them out by hand. So you're going to need to be extra patient today. So I'm going to call the docket. When I call the docket, you need to stand and let me know you are here. All right. In custody, we have Christopher Davis, Dylan Bell, Joe Blake, Celine, how do you pronounce that last name? Wante. Jonathan Lopez, Jonathan Ovidio Lopez, Noah Neelam, custody, Tyrese Jackson, custody, John Casanova Paez. Thank you. Juan Tehran III, Jose Sanchez, Tigo Yannick Prescott Amoa, Tigo Amoa, Tamika Studmeyer, Ivan Pacheco. Thank you. Sarah Gutierrez, Sergio Chavez, Michael Perez. Thank you. Rogelio Valero Jr., Brandon Diaz, Elisa Hernandez, Marie Miles, Dallas Vasquez, Travis Mann. Thank you. Zion Taylor, Amber Marie Salazar.
Present.
Thank you. Gilbert DeLeon. And custody is Renee Hernandez, Anthony Villarreal, Richard Trevino Martinez, George Moncada, custody, John Anthony Martinez. Thank you. Brian DeAnthony Parker,
In custody.
Thank you. Pedro Arbezo.
He's present. Your Honor.
Thank you. Christian Alamanza. Marlon Daniels.
He's present with counsel, Judge.
Alfred Flores. Elazar Alejandro. Thank you. Nathaniel Villalobos. Good morning. George Hawkins, custody. Angela Pettis. Angela Pettis. Monroe Hurd, custody. Dorothy Pettis. Dorothy Pettis. Yadhara Romo. Tony Torres Jr.
Here, present.
Austin Gibson.
Present.
Abel Martinez III. Anthony Chacon, custody. Joshua Mackey. Joshua Mackey. All right, anyone who came in late or your name was not called? Yes, what's your name? All right, did you come in late? All right, let me see where you are. All right, we have you. You need to sit on the first row. Yes. Anyone else who came in late or your name was not called? All right, the lady with the shades. Are you on the docket today? All right, just have a seat. All right, everyone, these are the rules. Attorneys, follow these rules and the docket will run smoothly. You don't follow these rules and things are going to get complicated and we're going to be here longer than need be. Number one, do not talk behind the court reporter when we're on the record. How do you know we're on the record? Because I will have called the style of the case. If you have a client who is in the box and you're talking to them and we're on the record, just ask the deputy, they will move you to the other end. Number two, if you have a client in custody, yes, they need to be brought out. Ask the deputy. Once you request your client who's in custody, do not leave the courtroom because for security reasons, there's a limited number of people who can be in the box and who can be out here. If you request your client and then you leave, you're being selfish and not being kind to your colleagues. Do not approach the court unless you have conferred with your client and conferred with the state. Important that some attorneys never remember. Ask the coordinator or the clerk to pull your file when you are ready to approach the bench. Once you have told them, they will pull your file, have a seat. I will call you in the order of appearance. There is no need to stand in the aisle and stare me down because guess what? You're going to be called in the order of appearance. So if your file is third on the pile and they will put it in order of appearance, if your file is third on pile, guess what? You're not going till after two other attorneys have gone before you. So don't stare the court down. The other thing is criminal trial division is right there. Family violence is right there. To make their job easier and to make this a true Friday's Eve, just grab your file, place your file on the desk of the prosecutor, have a seat. They need to review your file. And guess what? When they're ready to confer with you, they will call you up. They will confer with you. Do not, when they're conferring with another attorney who's before you, do not bogart your way in and start trying to talk to them and talk over them because guess what? You're being disrespectful to your colleagues because they were there first. Those are the rules. If we follow those rules, everything would go smoothly. Do not approach the clerk or the coordinator asking for a continuance, asking for a reset. I'm the only person who can do that, and I will only do that in the order in which your file was sent to me. The other thing, if your client wishes to speak in a language other than English, whether you speak the language or not, we're going to need an interpreter down here. Just ask the clerk and let them know that you need an interpreter for your client. Once you've requested an interpreter, do not leave because we have a limited number of interpreters and they will only come in and be here for about 5 minutes. And if you leave, guess what? That interpreter is going to be sent back to another quarter upstairs. And as punishment, you know what I'm going to do? You're going to be the last person to go. So if we follow these rules, everything will be great. And I've started to do the put you at the end of the pile for not following the rules, because that's the only way people will follow rules sometime. So everyone, please confer. And Bashan, I do have that email, so I'm going to email them now.
Address file.
Mhm.
Mr. Hawkins,
Yes,
that's gonna be in the afternoon.
okay. George Hawkins, right?
Yes.
Okay.
VTC has their staffing around noon, so
Mhm.
they'll be able to provide an answer to that.
Okay. All right. We're good.
No.
Well, yeah, yes.
Deputy Laura Hawkins on the recall, he's going to be at 1:30.
So we have, the state has the paperwork. The state's got it. So.
This attached to.
Not a close one.
All right. All right.
Sure, yep.
No. It's okay. I sneak up on people because I'm small. No, not on a. I've never seen that. What's possible? That means.
No, that's fine. I didn't see it.
It was just. I will have read the current. No. No.
All right, State, are you ready on Marlon Daniels?
The only thing we're doing, we're gonna print out the police report.
Okay.
I think that's for the hearing.
Okay, all right, thank you. All right, Austin Gibson.
The last time, I know they didn't have any issues,
Mhm.
so, who's here, Claudia Rushing should be on the Zoom.
Yes, I'll let her in.
And spoke with her the last time we had court as well, so
Okay,
we're ready.
all right.
So. I'll text you, no matter what. But I can fill with a note. Of what Valentine's is. Yeah, it'd be no problem.
Family violence.
Yes, Judge.
Have you all had a chance to review Austin, Zachary, Mark Gibson? Is it family violence?
Let me see if I can find it.
I believe so, Judge. This, let me, I'll talk to her.
Okay.
Okay.
Yeah,
all right.
sounds great, Judge. Absolutely.
Sure. Hey, it's going to be a beautiful day today. See?
Right, right. Yeah, you can always put it on. Is the worst case. More typical. That is, yeah, 75. That's what I'm seeing. That's not that it's a worthy account. It's a.
Yeah, there you go.
Yes, okay. Yeah. We can. Literally right on the. Yeah, sounds great. Yeah.
John Anthony Martinez. Hello. Oh, you're on this side.
Oh, yeah, you're right, Judge.
That's okay.
Exactly.
Yes, ma'am.
Real pen.
People are always wondering why the change. I said, the deputies are in charge of security and that's the way they want it set up.
Yes.
So where are we on this case?
I think we're about 95% of the way there with discovery, Judge. I'll make
with my snail mail note here, I'll make a request to just follow up. There's a mention of a video within a video that I want to just confirm that we have, and otherwise, discovery wise, I think we're in good shape, Judge.
We are in agreement with that as well, Judge. Just that one thing, want to get confirmation.
All right.
And this is our very first setting, Judge.
Okay. So what I will do is I will recall you for June 27th.
Okay.
And that will be your final date for discovery.
Yes, Judge.
And once I give you the reset form and your client signs it, you are excused. Thank you for dressing appropriately for court.
Thank you, Judge.
Martinez?
Oh, yes. Thank you.
Oh, you.
Thank you, Judge.
You're welcome.
Thank you.
Yes.
You ready? All right, are the parties ready on Austin Gibson? All right, court is going to call 2019 CR 8096, State of Texas versus Austin Zachary Mark Gibson. Could I have parties announce for the record for the state?
That's done for the state. Jason Garrett. Cheers.
And are you Mr. Gibson?
Yes.
All right, we're here. There was a request by probation through Mr. Gibson for him to have his conditions amended to no harmful or injurious contact with Claudia Rushing in lieu of the no contact order. I've reviewed the file. She's not the complainant in this case, but the court entered the no contact order due to the nature of the offense.
And Your Honor, just to let you be aware, there was a case where she was the victim.
Okay.
I don't know if it was TIC or if it was just dismissed outright. It
Okay.
was an ag assault.
Let me see. Yes, it was NIMAG number 552093.
My JD is not working, Judge. So,
Oh, yes, I know JD.
but I believe that's correct. I believe because I did happen to know that case was dismissed for whatever reason.
All right, and probation, do you have a report for the court?
Judge. Since the last compliance hearing, back in April, he's been visiting with, Claudia Rushing and the children as you directed. There has not been any kind of issues, or anything with those visits. The CSO assigned to Mr. Gibson did speak with Ms. Rushing, who reports no issues. And she states that she and the children hope that he can return to home. He's completed lifetime. He was residing at the Oxford House, but he couldn't afford to continue living there. So right now he moved in with his brother-in-law with his brother-in-law. But there is some other issues to, there are requests for him to be able to move back in to help with the children, and to get the family back together. He continues with his weekly sober support meetings and aftercare treatment. The probation officer doesn't seem to have any issues or qualms about him residing back with Miss Rushing. And I've asked her to join the Zoom meeting today. Judge, I did forward you a court summary, so you can kind of overall look at the case
Yes.
in your email.
All right. And I do see in the court summary, and I'll give you this part.
So Judge, we are asking for you to lift the contact restrictions and allow Mr. Gibson to reside with Miss Rushing and to continue with a no harmful or injurious contact order.
Okay. All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do
All right, you can lower your hand. How many days sobriety do you have?
have 7 months and I think 3 weeks.
All right, so how often are you doing AA or NA meetings?
I've tried to get 3 to 5 meetings in a week, and then I'm doing my, as needed with outpatient from my time.
All right, and are you employed?
I'm currently not. I'm doing staffing through People Ready, and I'm currently actually have an interview today with Wash Tub on as well.
All right, and what time is your interview?
He said just come by at any time before 6.
All right, and how old are your children?
My daughter is a year. The oldest boy is 11, and the other one is 9.
All right, so you say your daughter is a year. So the other 2 children, are you their stepfather or biological?
Yes, I'm stuck.
All right. It always perks up my ears when people sort of seem as though they're putting more favoritism on their child when they're a stepfather.
I'm definitely not.
All right,
They're all equal to me.
okay. All right, any other questions?
No.
All right, so I'm going to call Miss Rushing in. All right, could you unmute, please?
Hi, hello.
Hello, could you raise your right hand for me, please? Do you
Yes,
solemnly
ma'am.
swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
My name is Claudia Rushing.
All right, any questions?
Ma'am, in this particular case, would you want Austin to move in with you?
I'm sorry, could you repeat that again?
Would you like Austin to move back in with you?
Yes.
And back when this happened, there was a case of aggravated assault where you were named the victim, is that correct?
Yes.
And you chose not to press charges.
Yes.
And can you tell us briefly what happened that day?
So Austin came to the house and he was under the influence of drugs. I'm assuming he looked kind of out of it. He got upset because he wanted his money. He had $200 in the bank and he wanted that money. And I told him, that money was for bills, that we were not going to touch that money. And he got, I guess, he got agitated maybe because of the fact that I didn't want to give him the money. And so he grabbed a knife from the kitchen and, was telling me to give him his money back. And then I just told him, hey, I'm going to call the police. Like, if you don't leave, I'm going to call them. And then he just put the knife on the table and then he left.
Okay. And were the children present at that time?
So both my older kids, they were sleeping. This happened around, what was it, like 5 in the morning, 5:30-ish in the morning. So the boys were sleeping. The only one that was up or was woken up was my daughter. Well, our daughter, mine and his.
Okay. And so when Austin was on drugs, did he have violent tendencies?
I mean, apart from him like pinning me against the wall and then, then with the incident that happened, outside the house, as not really. I mean, he never hit me. I mean, he didn't hit me. He didn't like put his hands on me apart from like what I told you. That's all he did.
Okay,
And I did tell the police that day, that I think that Austin shouldn't, be in jail. He should get help, like be in rehab or something, because of his relapse. And so I did tell them that I didn't want to press charges on him. I just wanted him to get help because, I care for him. We have a kid together. I want my child to have her dad, And so what I honestly think it's just he needs to continue to do what he's doing right now so that he can stay sober, and get help. That's all.
okay, well, that was my next question. Since that date and since he's gotten help, has he ever done drugs that you're aware of?
No.
And if he does do drugs, would you call the police and inform the police or the probation officer about that?
Yes. I think, what's important is that he stays sober. And so I will do what I need to do so that he can stay that way. Get him help, tell the probation officer, tell him like, hey, you need to tell your sponsor, tell somebody, push him to get help.
And do you know who his probation officer is?
Sarah Davies.
So you have her number.
I have her number. I have her email. Yes, sir.
Okay, thank you. No further questions, John.
All right. Ms. Rushing,
Yes, ma'am.
since he's been allowed to have contact with you, what is a normal activity that you all do together or do with the children?
We've gone to the mall to go, eat and just eat, walk around. We took family pictures on the what was it, on the 17th. We took some family pictures and we have gone to the park, we've drove around. He's had good contact with the kids. It does get a little bit depressing, at the end of the visit because the children will say and ask like, oh, when is daddy coming home? Or why does daddy have to leave? So that is always, like the downside of the visitations,
All right. And do you have any fear of him?
No,
Do you have any fear of him being around your children?
no.
All right. So here's the thing in this court to be successful at probation, and I think people are aware, and I know the state does this as well, and so does probation. We want people to be successful on probation. Otherwise, the state would not have requested that they be on probation, and I would not have agreed for them to be on probation. So with sobriety, you cannot slack with it. You have to be vigilant about it because if there's a slip up, then it's going to lead to other things. He's on probation. He's not allowed to drink alcohol at all. So if there's an event, and I know we have the 4th coming up and other holidays, Juneteenth coming up, he is not to backslide. You're not to backslide, drink alcohol, because then that just downward spiral. Do you understand?
Yes, ma'am. I actually don't drink and he knows that, so that shouldn't be a problem.
All right. So this is what the court will do then. State, do you have any objections to lifting the order of him not being allowed to live there?
No.
All right. So I'm going to alter them in conditions. We're going to do the UA hotline for 60 days. You're telling the court that you do NA or AA meetings 5 times per week?
3 to 5, as
Okay.
many as I can get to this.
So I'm going to require NA or AA meetings 3 times per week at a minimum, because that appears that's what's we're working for you. And I'll lift the no contact order. And defendant, you're allowed to live with Miss Rushing if she wants you there.
I do have a question. Am I able to get like documentation that I'm here today? Because I do have a meeting with Lifetime this morning. And I don't want
Oh,
to be,
yes.
I don't want to be,
Yes,
Unaccounted.
let them know that you're gonna be late, but you're on your way.
okay, yes.
All right. Is there anything else?
State your honor.
Miss Rushing, is there anything else that you need from the court that you think would be beneficial to Mr. Gibson?
No, I think you guys have done everything. And like I said, I will make sure that he stays on tracks with his meetings, his medications, whatever help he needs from me, support that he needs from me, I will be here.
All right.
And
And
so
is
I
there
thank you guys for everything.
Oh, thank you so much. And thank you for coming in by Zoom.
Yes.
Is there anything else you need from the court?
No, ma'am, that's it.
All right. So we're off the record. So you know, if you need something, you need to let us know.
Yes, ma'am.
And you're the first person I've had before me who has 4 first names.
I know, everybody tells me that.
All right. Have a great day. Okay. Thank you, Miss
Thank you.
Rushing.
Thank you. Have-
Oh, I'm sorry. Let me see that file. I forgot to write one thing.
I'm not.
Yes. See, I thought he had already had the no harm for injuries because I had them. Okay. All right, yes.
Yes, just say upward to the.
Well, that was nice. Thanks, John.
And put no harm for injuries with Claudia Rushing as well as the children. No.
Yes. And then the ninth.
Madam Mayor, Coach Quirky, Mr. Norton had a question and an issue that I think he has on the schedule. I'd like to go to my office and resolve it.
Sure, okay,
And the other two co-defendants, just out of abundance of caution, bring them with.
okay. All right, Marlon Daniels. State, are you ready on Marlon Daniels? All right, court is calling night mag number 7588930 and 7588931, State of Texas versus Marlon Daniels. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
George Sharman on behalf of Daniel.
All right, and are you Mr. Daniels? All right, we're here on a motion in each of these cases to alter and amend your conditions of bond. State, have you had a chance to review the request?
Yes, Your Honor.
All right, state, do you have objections?
Yes, Your Honor.
All right. Defense, do you have any witnesses?
I have Ryan Spencer, his daughter here.
Oh, well, call your witness.
Well, I'll call Ryan.
Ryan Spencer?
Put it on the table.
Hello, good morning. All right, make sure you keep your voice up so the court reporter can hear. Could you state your name for the record?
Ryan Ashley Daniels Spencer.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, yes.
All right, you can lower your hand. Defense?
All right, would you tell the judge your relationship with Mr. Daniels?
Marlon is my father.
Okay.
And do you live with your father?
I do.
Who else lives there?
I have 2 little children, my 8-year-old and my 6-year-old, myself, and then I'm currently pregnant.
Now, does your father have a job?
He does.
Is he currently employed?
Currently, yes.
Now, is he able to work from home?
Right now, they're not allowing him to, They just need understanding that he's able to go to work physically, and maybe something from home could be worked out eventually. I'm not too sure.
Are you available to give him a ride from your house to work and then from work back home?
Yes, yes,
All right. Are you asking the court to allow you to do that?
yes, please.
Do you have a vehicle?
Yes, I do.
Does it have an ignition interlock in it?
No, it doesn't.
Would you, now does Mr. Daniels have access to that?
We live together. It's at the home. As far as him driving it, no, but we do live together, yes.
In order to get the opportunity for you to drive him to work, if the court so requires, would you be able to put an ignition interlock in that car?
If that's what's deemed necessary, yes.
What are you asking the court to do for him right now?
To allow him to be able to go to work physically. I believe that is the only thing the employer is preventing him from being able to actually go into office or work at all. So just for him to be able to go to work.
Now, why is it necessary for him to go to work?
Because I mean, he accumulated bills. It doesn't stop, nothing has stopped. I can only help financially so much. I know going to work would help alleviate the stuff that has came up and help assist with what's going on currently.
Can you support yourself and him if he doesn't work?
I can't do that.
So is it necessary for him to go to work and be paid by Social Security Administration?
Yes, it is.
Is that where he works?
Yes, it is.
He's a government employee
Yes, he is.
and he currently has a job.
Yes, he does.
Has he used his leave from his job? Does he have
Yes.
any leave left?
The only leave that I know of is his sick leave, which they are not allowing us to utilize.
All right. And if he were allowed to work, would you be able to tell the court that you would make certain that he doesn't leave the house except only for work?
Oh, definitely. That's the understanding. He's home now. If he is granted permission to go to work, the only place that he's gonna be allowed to go is to work, to and from work. So yes, that would be what we're going to do.
Now, does he have an ankle monitor?
Yes, he does.
Is that a GPS monitor?
Yes,
Is it expensive for him to have that monitor?
yes.
All right, so let me just stop you right there. State, do you have any objections to him being employed and going to work?
Judge, I was misinformed. I was looking at something else.
Okay,
So that's what I was looking for. I don't think at this point the state would be opposed for him to be able to work. But we would be opposed to any vehicle being at that household that didn't have ignition interlock that he possibly would have access to.
all right, so I like to get to the point sometime because maybe a lot of testimony is not needed, but if more testimony is needed, you all just let me know. So is this the only vehicle at your house? You only have one vehicle?
Yes, ma'am.
All right, so that vehicle is going to need ignition interlock on it. All right, so that's off the table. So
All right.
next
now,
thing,
Judge,
employment.
I'm sorry to interrupt, but I had asked them about that and they told me they opposed.
Well, here's the thing. We
Okay.
are where we are now.
All right.
Everyone, sometimes people hear testimony and things change. Sometimes what I'm going to do originally, once I hear different things, maybe, what I'm going to do changes. So, when you're getting what you're asking for,
So I'm not a,
let it lay there.
yes, ma'am.
So they want you to have ignition interlock on the vehicle. Are you going to be able to do that?
I need to understand what that is and what I'm going to be responsible for.
Oh, well, it's a device that's placed on your vehicle. And anybody who's driving that vehicle, they have to blow into it.
Okay,
Now, state, if that vehicle has ignition interlock on it, are you okay with him driving or no?
Oh, no.
All right, so even though your vehicle will have ignition interlock on it,
okay,
he's not allowed to drive it.
okay.
All right, so Uh, there's to be no driving. Now, the next thing, with regards to the GPS, do y'all still want him on GPS? All right. Counsel, I understand why they want him on GPS because it's the nature of the offense.
I understand. We're just asking if you would waive the fees for him because they're having some difficulty.
All right, I will tell you what, I'll put in there to waive the fees or defer the fees. The problem is, these are third-party contracts. So I have no authority to tell them the fees must be waived. So I'll put in there that the fees are deferred
Okay,
or either waived. If they waive them, great. If they just defer them, great.
okay,
There's supposed to be a monitor that's free. I don't know where that monitor is. So I've been trying to figure out where's the free monitor and who has it, but that's where we are. So he's going to be allowed to work. State doesn't have any objection to that. There has to be ignition interlock on the vehicle. He has to have GPS. The GPS fees, I'll ask that they be waived or deferred. Anything else?
That's all we want, Judge.
All
Thank
right,
you
see
very
how this hearing ends very quickly on a, Friday's Eve?
Can I
Yes,
ask okay, so with the interlock, is that a fee as well monthly?
that is a
So
fee.
Am I able to request a waiver on that one too?
I'll ask that it be waived or deferred, but I can tell you right now, what I'm going to get is I'm going to get an email from that company and
Mhm.
somebody's going to say, Judge, you're not allowed to waive fees on that. I know I'm not, but I write it down anyway because maybe some person will say, hey, we just found the free monitor,
Gotcha.
but you will have to pay for it though.
Okay, but as long as he's able to go to work to help assist, that's fine.
Yes.
Okay,
All right. Thank you so much for coming in.
thank you.
Judge, would there be a written order for pretrial
Yes.
services? Okay.
Yeah.
Okay.
All right, Mr.
Thank you.
Daniels, if you'll come forward, please. Yes.
Okay.
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Marlon Demetrius Daniels.
All right, so Mr. Daniels, you understand that you are not allowed to drive at all. Do you understand?
Yes, ma'am.
So if it's discovered that you're driving, a motion is going to be filed by the state. You'll have to come in and we'll hear that. You understand?
Yes, ma'am.
Is there anything that you do not understand about the court's orders?
No, ma'am.
All right, so you're allowed to go to work only. If something else comes up and say you want to go to the grocery store, you have to come back in and get an order for that. You're only allowed to leave the house to go to work. Do you understand?
Yes, ma'am.
All right. Thank you all.
Thank you, Judge. I guess we're excused now. He has to go
Yes.
because of pretrial service.
Mhm.
I submitted the talk with last week.
Okay.
So. And then I forgot to come back after lunch. I was here, anyways.
So is the system down? Sarah.
What does the system show us? All right. Wow. Thank you. Yeah. What's that? I don't know, that's just speaking minds.
And Vashon, whenever you're ready on Nelum, just let the court know.
Waiting on,
Okay, thank you. Yes. Okay, all right, just give me a moment. Okay, sure. And Brian, I'll take that up just after I finish writing this order.
Silver lining.
All right, there's that. All right, Brian.
They call him up, Judge?
Yes. Hello.
Hi.
All right. So you've had sufficient time to speak with your client?
I have Judge as well as his counsel in California.
All right. So you need to appear when they ask you to appear. If you don't appear, what's going to end up happening is they may end up issuing a warrant for your arrest and they'll hold you until you appear. You understand?
Understand.
So I have an attorney here for you so they could perhaps discuss, and I'm assuming you discussed the options and what's on the table if you do not appear. Do you understand?
Understand.
All right. So my job is I receive the document from California. California have a hearing determining that you're a material witness there, and then I sign it.
Okay.
All right.
Thank
Do you
you
have
very
any
much.
questions about anything?
No.
All right. Thank you, Mr. Powers.
Thank you. Judge, is Norma on today?
No, she's out.
What do I do? I was going to request, I filed a motion to switch from partial to tracking on GPS on that Eric Cantu case.
Oh, just, I'll hear it. Okay, just 1 second. And make sure that this document, that you have everything.
This is attorney.
Yeah, if you just pull everything, I'll look at it.
Oh, okay, Judge.
Sure.
I've got the motion. I can provide that to you and I'll go get
Yes.
the copy.
Okay, awesome.
Your docket when you're, in that minute. Gonna find somebody.
All right, who is here on Joe Blake?
Good morning, Your Honor.
Good morning. You want to come forward? You ready?
Mr. Blake?
Did she give us a written order on mine? again?
And Jan,
And I take it to the back.
hello. Court is calling 2015 CR 2807, State of Texas versus Joe Blake. Could I have parties announced for the record for the state,
Casey Garrett, Your Honor.
for the defense?
And Mark Darling for the defendant, Your Honor.
And are you Mr. Blake?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Thank you.
Are you the same Joe Cassius Blake, who was placed on community supervision in 2015 CR 2807 for the offense of driving while intoxicated third or more on September 14, 2015 for a period of 5 years and extended for a total of 4 years?
Yes, Your Honor.
Yes,
State?
Your Honor. Highlight condition number 5, in Ventura County, Texas, the defendant Joe Casillas Blake did then and there fail to report to the supervision officer in person or through virtual means, i.e. Zoom, for the months of June and July 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated condition.
Any objections?
No objection, Your Honor.
All right, off the record for a moment. Zach, if you could let Brian know that his client will still need to be served with that order, so his client shouldn't leave until that's done.
Okay, yes.
All right, thank you. All right, we're back on the record. Mr. Blake, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, and sentence you up to 10 years in prison and up to $1,000 fine? Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, sir.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There it is, Your Honor, and it is to grant the motion, revoke the individual officer's probation, and to reform the underlying sentence of 10 years to 5 years.
Is that your agreement?
Yes, Your Honor, that's what we're hoping you consider.
All right, Mr. Blake, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, if you'll state your name.
Joe, C. Blake.
All right, you can lower your hand. What happened? Why didn't you successfully complete this probation?
Going through rough times, lost my job, got separated from my wife, and just everything was going.
Okay, you realize that you can't go back to drinking. You understand?
Yes.
I'm going to follow your agreement. I'll request the therapeutic community because I see that you were given inpatient treatment, but you didn't successfully complete it. So I'll follow your agreement, sentence you to 5 years in the prison, give you credit for any time served. And I'll ask for the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. So the 5 years you received, if you're still working on things in the therapeutic community, they're not going to hold you. You understand? So it's just to help you hopefully be better when you're released. All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, when you're released from custody, don't go back to drinking. If you cannot find an inpatient treatment place, if you need one, or if you need an outpatient treatment place and you can't find it, you can always come back to court if I'm here and I'll direct you where to go, okay? All right, good luck to you.
Thank you.
You're
Thank you,
welcome.
Judge. And I apologize for, I forgot to come back. I had a hearing at 1:30. Anyway, I
You
appreciate.
forget about us. We're not even on your radar.
Well, it's not that- You know, I was all the way home, but thanks, Judge.
Sure.
Have a nice day.
Lindsay for. All right. Have they brought Nellum out? Could I see the file on Nellum, please? And Brian, they just need to serve your client.
But you mean to bring it back in?
Yes, they just need to serve him.
Okay.
All right. All right, Mr. Tamby.
Okay, yes, ma'am, I can get you.
Hi, thank you so much for being here.
Yes, ma'am.
All right, the court is going to call 2020 CR 8296 State of Texas versus Noah Nellum. Could I have parties approach and announce for the record for the state? Defense? All right, we were here May 23rd. And I know the state had wanted to continue Mr. Nellum, as did the defense. I was swaying back and forth on that. So I asked that the persons at the home he was staying at be present. And so we have that person by Zoom. Both parties said that they would have no objection to the person appearing by Zoom, correct? Correct. All right. Mr. Tammy, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
My name is Augustine Tamby, and the co-owner of the Mafu Home Health, where Mr. Nellum was staying.
All right, does anybody have any questions, or are you all okay with me asking questions? All right, so I have some questions. I don't understand why the reason changes were made, and those changes were not approved by me. So my understanding is that he was staying at a foster home. Who placed him in the foster home and why?
So the program, which Mr. Nelum is, the home and community-based program, it's a program that is based on the individual's choice. We had Mr. Nelum in the group home, and while he was at the group home, his behavior was inconsistent with him living in the group home. So he made a choice that he wanted to live in a foster home where someone would then supervise him, a foster parent would supervise him. And even at that location also, he was not compliant because he was leaving the home unattended. He was given certain period when he's supposed to be home and he's not, getting back home at that time.
All right, so is he allowed to be in a group home? Do y'all have a group home for him? And if I allow him to be with y'all in a group home,
Yes, we do.
Okay, he's not allowed to make choices of whether or not he is leaving the group home and going somewhere else. Do you understand?
Yes, ma'am.
So do you have a group home for him?
Yes, we do.
Are you willing to accept him back?
We're willing to accept him, but we'll recommend, if at all, he'll be sent to, because while he was at the group home, he had some problems with drugs, and we would like for him to go to a rehab facility prior to coming to the group home.
All right, do y'all have a rehab facility available for him or no?
We did give him some choices and he refused to attend.
All right, so this is what's going to end up happening because both parties have agreed for him to remain on probation. He's going to go into inpatient treatment. And then after he finishes with inpatient treatment, will you all be able to pick him up?
Yes, ma'am, we'll
And
be able to
transport
do that.
him.
That's correct.
Probation, is there anything else?
No, Judge.
All right, thank you for coming in. Probation will be in touch with you when he's about to be released, and I'll put an order in that he's only to be released to a person from your facility.
That's correct.
All right, thank you so much.
Thank you, ma'am.
All right, so we're going to go off the record. Mr. Lamb, I want you to listen to me and listen to me clearly. You're doing this thing where, oh my gosh, let me look sad and downtrodden. That will only get you so far. It's not going to get you any further with this court anymore. The court considered your age. That is why the state offered you deferred for this case anyway. But if you are able to tell somebody you don't want to stay at a location, you want to stay somewhere else, then you're old enough to face real life consequences for your actions. If you're old enough to go out, find drugs, use drugs, or buy drugs, then you're able to suffer the consequences for your action. If you're able to take, without permission, the vehicle from your foster family, then you're old enough to deal with consequences. Do you understand?
Yes, ma'am.
Do not come back to this court again for this nonsense. You had better fly straight and narrow. Otherwise, a motion to revoke is going to be entered. And all of this thing where people are feeling sorry for you, it's going to fall on deaf ears. Do you understand?
Yes, Your Honor.
Do you understand what you're supposed to do?
Yes, Your Honor.
So you are going into an inpatient treatment facility for whatever drug issues you may have. And then once you complete that program, they're going to pick you up and you're going to be in their home. And you're not going to a foster home. You're going to be in that group home and you're going to follow their rules. Do you understand?
Yes, Your Honor.
And if you want to leave that home, guess what? You have to get permission from this court. Do you understand?
Yes, Your Honor.
Is there anything else?
Not from defense, Judge.
All right, probation, what inpatient treatment do you want him in? All right, so I'll deny the motion, alternate amend conditions. And we can go back on the record. I'm going to deny the motion, alternate amend conditions to include state ISF substantive track, and he's to be released upon completion to the MOFU home only. Is that MOEHU?
Yep. MAOFU.
Maofu.
Yes, ma'am.
All right. Is there anything else?
Nothing from defense, Your Honor.
Is there anything you don't understand about my instructions? All right. Thank you. Thank you.
Judge.
Thank you, ma'am.
And Ms. Abrams, if you have their number, or if you don't have their number, I will email it to you. Okay, thank you. All right, who's here on Tony Torres? Do you need some time to finish up with that? Okay. All right, Tony Torres? Hello.
Hello.
Let me look here. All right. Yes, probation.
Judge, we're here regarding a compliance hearing that was stated on the supplemental report. Judge, the CSO requested allow removal of the GPS device, require compliance and progress of conditions within 60 days, otherwise set for a compliance hearing. So that's why we're here. It appears that since January, Mr. Torres really hasn't made much progress in regards to his conditions, to include providing proof of income, parenting class, victim impact panel, DWI intervention, sober support meetings, and an affidavit of non-driving. He was instructed to submit UAs on 2 occasions, and he failed to submit those in February and in March. He did present a negative in April. However, today we did obtain a positive UA for cocaine.
Medication.
No, cocaine doesn't.
I take 18. Take Trazodone, Adderall, Seroquel, Xanax.
So you're saying there's a prescribed medication
No, I
out there
take a
that,
lot of-
no, stop. You're telling me that there's stop chewing gum.
Oh, I'm sorry.
You're telling me that there's a prescribed medication out there that would give a false positive for cocaine?
Sure. I haven't
No.
done nothing. I haven't
No.
done nothing.
My question is that what you're telling me?
I'm not a doctor. I'm not sure. But with all due respect.
Well, here's my question. And you're not under oath.
Behind your back.
Have you used cocaine?
No, I haven't.
All right, so
I've been at home.
then the only other option is you're telling me that there's medication that will cause a positive for cocaine.
I'm not sure. I haven't even drank. I've been at home almost 3 months.
All right.
And I take 18 medications. I have all my papers from my doctor prescribed too. I haven't done nothing.
All
I
right.
haven't even drank.
All right. So I'm not removing it. I can't be removing GPS when somebody's testing positive for cocaine.
I don't know what to say. I've just been at home almost
Right.
3 months.
So, I mean, it's
I
not
can't
getting
step out of
removed.
the door, so,
It's not getting removed.
okay. If you like, I could give you all the documents of my medication. Like, I don't do it.
I don't know of any medication that will
Yeah,
cause you to,
I don't know what it would do.
defense attorneys.
Sorry.
Is there any medication that you all know of that would give me a positive for cocaine? Kanee's gonna come up with an answer.
Trazodone, Seroquel, Adderall, Xanax, I take a lot. Seroquel, I have all prescribed.
Here's the
medication.
thing, Seroquel doesn't
Yeah,
give,
but mixed in me. I take them every day because I have anxiety.
no, that doesn't, none of those drugs give you
I don't know. I
false,
haven't done it. I'm done it. I haven't.
but this is what I'm telling you. You know, sometimes, you know, I don't know everything. I don't pretend to know everything. Maybe there's a new medication out there. That's why I asked the defense
I'm not saying there
attorneys.
is, but I haven't done nothing. I've been in my house already almost 3 months. I can't go step out of foot, so.
Mhm.
I haven't even drank. I haven't even drank.
All right, probation. This is what the court is going to do. I'm not removing GPS. And he's going to be subject to the UA hotline. Here's the thing, if you have a drug or alcohol issue, guess what? We can work with you on that. I can figure out something that could help you with that. But I'm not removing GPS. And so we're going to do the UA hotline.
What is that?
Yes. All right, and then I'm gonna, your TAP evaluation recommended outpatient treatment. So we're gonna do dual diagnosis. Outpatient treatment.
Then I've been getting random visits from the clubs, like big one, like every.
And we're gonna do 120 sober meetings and 120 days. All right, so here's the thing. I want you to be successful on probation. If I didn't want you to be successful on probation, I wouldn't have agreed for you to be on probation. So you have got to be honest with yourself and look in the mirror and be honest with yourself. Guess what? Where you are now, hopefully this is not where you're going to end up, where you're positive for cocaine all the time.
Yeah.
All of us, me included, we're all trying to be better people and improve our lives, right? Nobody's perfect. So you're going to have to not use drugs because you're on probation. You're not allowed to. Do you understand? And don't come before any other judge. If you're before a judge, telling them that you're positive for cocaine is because of your prescription medication. All right, you understand? All right, probation. Is there anything else? All right, good luck to you. If you need something, let the court know. Deputy Laura, Cornelius Cox is a great attorney. Nobody else was coming up with a potential reason for the court. You know, so. All right, Abel Martinez. Hello. All right, so you know what? Because this is going to end up having to be a restitution hearing, and how old are you?
21.
All right, he's young. Let's appoint an attorney for him to address the restitution issue. Can you mute us for a moment, please? All right, just All right, who's here on Eric Cantu?
Just trying to figure out if I need to set it for a hearing or not. It's not, this is the one where these the state's recusing themselves, so it's kind of an odd issue, but
Okay, because they haven't. Yeah.
no, not yet. But I was just asking that the GPS be switched from virtual to tracking. And so he's been getting therapy for the trauma that he sustained from the gunshot wounds. I am
Here's the
asked,
thing, I don't think the state will be objecting to him having, or if the state, since you're trying to recuse yourself, if you don't want to give input in it, that's fine. But I don't think anybody would have a problem for him to go to any medical or psychiatric appointments.
well, I think, Judge, what we're just asking for is, one of the primary issues, just we're asking that he not be able to drive, that be a condition, but that the GPS be moved to tracking, because I think that's been kind of. one of the
No,
issues.
I'm not going to do tracking for GPS.
Can I-
So, I mean, if you're just asking that he be allowed to go to his medical appointments,
Currently has that as a condition.
okay, then, I mean, you want to go on the record?
No, that's all right. Judge.
Okay.
I just wanted to check with the court.
All right, thank you. All right, and we're waiting for an interpreter for someone. Juan Pacheco. All right, so what is happening with the federal case?
Your Honor, my client's waiting on a PSI date still. He was told it would be 90 days. It's been about 90 days, but he still hasn't gotten a court date yet.
All right, has your attorney on the federal case given you some idea when that will be?
She had told me to be soon, Your Honor. I spoke to her last week. She said it should be coming in, but there's no date yet.
All right. So State, were you able to tender an offer?
It's a little bit different type of case. Judge. There's some things going on that my investigator is going to be going to just Blake's office with Blake, it is Blake.
Yeah.
Okay, so, her office to collect some items in this case. So it might be resolved differently than through an offer.
All right, so I'm going to give you all till July 11th. Is that enough time for everyone?
Yes, Your Honor.
Yes, Judge.
And once you sign the reset form, you are excused.
Thank you.
Thank you. Have a good day.
All right. Counsel? All right, and has the interpreter been called?
Yes.
All right. All right, who's here on Christopher Davis? Okay. Then the next case we have is Dorothy Pettis. Hello, good morning.
How you doing?
Oh, I'm doing great. Where is she?
I'm not quite sure, Your Honor. I haven't had contact with her in about a year. I do know that pretrial services submitted something to the court on the 25th saying that they just got in contact with her. So I can reach out to them to see if I can get a good number for her, but as of today, I don't have contact with her.
No, they've said that they haven't had contact with her.
I think on the 25th, they sent something else saying that they updated it, saying that they did, that she had contacted them on the 25th.
All
And that
right.
they were requesting to have it continued.
Do you have any objection to my sending an email to them? Because
I have
I
no
don't-
objection.
do you have the email?
I'm pulling it up right now.
Okay.
Would you like to show it on my phone?
Yes.
This is the update.
Okay. All right, thank you. I'm gonna reset this though, and she needs to be in court. What is a good date for you?
Um. Would we be able to do it, on the 13th of June?
All right, let me, 13th of June?
Yes,
Let me look at the calendar.
that'd be, not next Thursday. but the following Thursday.
My computer's moving very slow. Yes, we'll call it back on June 13th.
Thank you, Your Honor.
You're welcome.
May I be excused?
Yes.
And I just want to apologize for not making the announcement last week.
No.
She wasn't here, so I checked.
Oh, no problem.
Thank you, Your Honor. Have a good day.
You're welcome. You too. Sarah Elizabeth Gutierrez. All right. So where are we?
Your Honor, I'm subbing in today or helping out Mario Moreno. He has a vacation notice on file and he wasn't able to be here today.
Okay, when is he back from vacation?
He's back on June 7th, according to my email, but I can't verify it in
All
online.
right, so we're gonna recall this for June 13th.
June 13th.
Yes,
Honor, may I?
yes.
So the prosecutor still, it's already been, I don't know how many months, they're trying to prove that there's extra evidence that I had contacted Mr. Medlin within the order in violation. We're still waiting on that evidence. I don't know why it's taken this long for them to receive physical evidence.
All right, you'll need to talk to your attorney.
Okay, thank you.
All right, so I'll give you a reset form for June 13th, okay?
June 13th. Maybe we'd be excused after she signs it.
Yes,
Thank you, Your Honor.
Thank you.
you're welcome. And state that'll be the last discovery date. Who's here on Jonathan Lopez? Jonathan Lopez. All right, if you'll come forward. Court is calling 2024 CR 7889A, State of Texas versus Jonathan Lopez. Could I have parties announced for the record for the state?
Daniel Escobar with the state of Texas.
Defense?
Linda Corley for defense.
Are you Jonathan Lopez?
Yes, Your Honor.
Did you review a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jonathan Lopez who was placed on deferred adjudication in 2014 CR 7889A for the offense of robbery on February 2nd, 2015 for a term of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant, Jonathan Ovidio Lopez, who's in there, failed to report to the supervision officer as directed for the months of January and December 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True, Your Honor. Your Honor, state waives all the violations.
Any objection?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty and sentence you up to 10 years in prison and up to 10,000, I'm sorry, up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5. Is there a proposed agreement?
Your Honor, it's, both sides want to go to open.
All right, state, what are you requesting?
Your Honor, state requesting revocation 8 years TBC.
All right, defense, what are you requesting?
Judge, we have a witness here as well, if you feel that you need her.
Oh, let's
we're
call the
request-
witness.
Okay. Mr. Vance. I call Alondra Mata.
All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you're going to need to keep your voice up so the court reporter can hear.
Yes, Your Honor.
State your name for the record.
Alondra Mata.
All right, off the record for a moment. To the interpreter, I'm going to take you up as soon as this witness is done.
Yes, Your Honor. Thank you so much.
All right, we're back on the record. Defense?
Thank you, Judge. Can you spell your first name for the court reporter, please?
Alondra.
And how do you know Mr. Lopez?
He's my boyfriend.
And how long have you been together?
A year and a half
Okay. And in that year and a half, where has he lived?
with me.
And during that time, was he working?
Yes, he's been working. And
All right. And did he go to work every day?
yes,
All right. Has he been helping with bills and all your living expenses as well?
yes, he makes my car payment, pays half of the rent, and buys the food.
And during that time, were you aware that he was supposed to be reporting to probation?
No, I wasn't aware in the beginning.
All right. And so now you're aware that he had that requirement. You understand that we're here today because the state has filed a motion to revoke his deferred.
Yes,
All right. And you understand that means that at this point, he's not convicted felon. So we're here today to ask the judge if she would consider allowing him to stay on deferred. So can you tell the judge a little bit about your experiences with him, with the responsibility, and how he's been doing since he's been with you?
yes. Jonathan has been with me for a year and a half. When I met him, he was already working. We moved in together and he's been helping me pay the bills. From what I've been with him this time, he's been doing good. He hasn't done anything that shows, that he's going back to what he used to be. The person that I met is not what I know today. That was something in his past, so.
If the judge were to allow him to have another opportunity not to go to prison, why do you think that he would follow the rules at this point?
I think he's in a better place now, and I've never been in trouble, so I don't allow anything bad to, for him to do. So therefore, I know for sure that if he's with me, he's not gonna be doing anything wrong.
And you understand that he had used marijuana, and we waived those violations, but how do you feel about that?
He's not smoking and he's not going to.
Okay. If he was, would you report him?
Yes, he knows that.
Would you be there to help him to keep track of all the things that he needs to do?
Yes, I've been helping him with that as well. He's been checking in and on his own doing what he has to do. So he's been doing pretty good.
I'll pass the witness.
I just have a few questions. It looks like it was a shock whenever you found out he was on probation then.
Not as a shock, but when I found out, I did tell him, like, you have to do the right thing now. And this is what he's been doing since he's been with me. So as far as when he got arrested, he's been following all the rules and I hope, that's what he's gonna continue to do if he's with me.
So it wasn't a shock when you found out that he had been placed on probation for robbery previously?
I didn't know that until now.
So he never once informed you of that?
No, not until I found out. So you found that out when he was arrested on this charge? Yes. And, based on what you knew of him, was it a surprise that he would have had a case like that? It is because he's a good man. He really is. So when I found out what it was, I didn't believe it, but he's with me and he's been doing good. So I think that's the person that he's trying to be from now on. No more questions, Your Honor.
I have a few questions. When did you meet him?
January of 2023.
Where did you meet him?
I met him on social media.
All right. And when you met him, when did he tell you he was on probation? Did he ever tell you?
No, he didn't tell me that he was on probation. He was working, so we just, continue like.
Well, no, how did you find out he was on probation?
Not too long ago.
When he got arrested?
Yes,
All right. And then that's when he told you he was on probation?
yes,
All right. Do you have any children?
yes.
What are their ages?
17 and 21.
All right. And then you said that he pays the bills?
Yes,
All right. Do you pay any of the bills?
yes, I do. I have a job.
All right. And this marijuana use, did you know he was using marijuana?
No. In the beginning, I knew, but he stopped.
Okay. All right. Thank you so much.
Thank you.
Yes.
Judge, I would like to call Mr. Lopez.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Jonathan Elvidio Lopez.
All right. Defense?
Thank you, Judge. Jonathan, you know this, we're here in front of the judge, and this is your third NTR, correct?
Yes, ma'am.
All right, so you've had problems while you've been on probation when you started, is that correct?
Yes, ma'am.
Can you talk to us about what was the underlying cause of those?
I was at the time, I was in a very dark place, and I lost my jobs and went through a major breakup with the mother of my children, and I just felt like everything was, everything was just on top of me, and I was in a dark place, and I was using marijuana as a dumb decision instead of reaching out for help and getting help from the state and myself. I put myself in a bigger holes than I was already in. And
you went to outpatient treatment, right? And you completed that successfully once, and you went a second time, and you did not complete that second time.
Yes, ma'am.
So what happened there?
I just was, I was out of work and stuff, and I was embarrassed of like asking for help, and I just didn't. My phone had broke, and I didn't continue with the Zoom.
So at some point, you started climbing out of your depression. What was the catalyst for that? What changed in your life?
I started going back to church, and seeing my kids was, it gave me hope again to do everything that I needed to do and get back on track.
And on your prior NTRs, you had turned yourself in, and on this NTR, you knew you had a warrant. At some point, you went to turn yourself in. Is that correct?
Yes, ma'am.
All right. And so you went to the sheriff's office
Yes, ma'am.
and you identified yourself, and they told you to wait.
Yes, ma'am.
So you waited there for some time,
Yes, ma'am.
and then you made a decision to leave. You got scared. Why did you leave?
I was there for about an hour. Everybody called me, and I made a stupid decision just to leave instead of waiting for them to come get me. And I I made a dumb decision and I left, and here I am back in court.
So, you began working, once you started seeing your kids and you started pulling yourself out of the depression, you started working again. Where did you work?
With my uncle doing roofing.
Okay. After you were arrested, he didn't want you to come back to work for him. Can you explain why that was?
He was dealing with his own problems with probation and other stuff, and he just didn't want me to affect with whatever he had going on.
And did that have something to do with your ankle monitor?
A little bit, because where he goes, we go to like certain places, and he didn't want for me to be on monitor and go to like certain places that he needs to go, like his bases and different stuff, for them to decline his contracts and stuff.
Okay. And so at some point you met Alondra,
Yes, ma'am.
and how did that change your life?
She's a good person, and we started going to church, and I feel like she's pushing me to be a better person than I was, and she motivates me to be a better person.
You know, this is your third MTR, correct?
Yes, ma'am.
Why should the judge give you another chance after she's already given you 2 chances? What's different now that you can assure her that if she does give you this chance, that you're not going to give her another reason to put you in prison, that you can be an upstanding citizen and continue working and being a good force in the community?
Before all this that I'm going through is, I was young. The case is over about 10 years old, and after that, I haven't picked up any new cases, and I haven't gotten like major trouble since then. And I know I made stupid decisions along the way. We're not reporting, doing the UAs and stuff, but I was using marijuana as, could I say, like coping mechanism, when instead of I should have asked for help and asked my probation officer for different ways, and I made dumb choices instead of
But you had
doing the
help.
right thing and going to.
So you had help, but you blew that, right? You had the outpatient and you messed that up. What was your mental condition at that point?
I was just in the dark place. I wasn't thinking correctly.
And you had picked up a couple of possession of marijuana, shoplifting, and a driving while license invalid at some point during your probation, correct?
Yes, but that was over 7 years ago.
Okay. And so are you using marijuana now?
No, no, ma'am.
If you were to test, would you test clean?
Yes,
You
ma'am.
understand the judge could send you for testing if she wants.
Yes, ma'am.
Pass the witness.
State.
Just a few questions, sir. So you never told Alondra about the fact that you were on probation, did you?
I told her that I was in trouble, but she really didn't believe me until I recently got incarcerated.
Did you ever explain exactly what you meant by being in trouble?
I kind of like explained it to her, but she just didn't believe because she didn't see that person. And I explained to her, and I would explain to her, and I told her that I need to make enough money to get a lawyer because I'm in, major trouble. And she didn't believe it. And when all this happened, when I recently got incarcerated, and I guess she saw for herself, when I came home, she still don't believe that. But I told her it was something that it's over 10 years ago. I believe everybody has a second chance or deserves a second chance.
You would agree that you've already had 2 prior MTRs, right?
Yes, sir.
So would that have been your first and second chance?
Yes, sir.
No more questions, please say.
All right, anything else?
Nothing, Judge.
Any other witnesses?
No, Your Honor.
All right, the court is going to find you guilty. Grant the motion. You all want to speak to time?
Your Honor, state's still gonna recommend 8 years.
Defense.
Judge, if. May I address the court about the issue? I understand that we can throw him in prison.
All right, so counsel, I will hear your issue, but here's the thing. I know that I'm not the person who placed him on probation because he was placed on probation in 2015. But since that time, you've had motions to revoke with me. And I know that I tell everybody, if there is an issue, let your probation officer know. If you feel like they're not addressing it, you can always come back to court. He's just disappeared. And I'm sure everybody has read the court summary. He's disappeared. And I internalized everything that was said to me. And you know what usually happens, Mr. Lopez? People will call witnesses to come in. And you know what? It's always the witness acting as though they're on probation. I'm going to make sure this person doesn't use marijuana. I'm going to make sure this person reports for probation. They're not on probation. You are. All you had to do was report. And guess what? If you're testing positive for marijuana, it is rare that I revoke somebody for testing positive for marijuana. I let them know. I know marijuana is legal in other states. If you want to make it legal in Texas, contact your legislature. But while you're on probation here, you're not allowed to use marijuana. And I know the last time we were here, you know, on your motion to revoke, where you were continued, I said those exact things to you. And now when everything comes to a head where somebody has a motion to revoke and they wouldn't report it, all of a sudden, everybody has their life together. I'm married. I'm engaged. I'm with a lady. I never told her I was on probation because you know what ends up happening? Guys, when they end up with women, sometimes women will fall in love with you. Maybe they're falling in love with your publicist. Maybe you haven't presented your full self. But I know usually when women fall in love with the guy and they don't know all of this history, then they get hit with the history. And guess what? They still in love with that guy, just like the witness who came to testify for you. She's still in love with you. She still wants to do everything to keep you out and about. But you're not a good candidate for probation. I don't consider it throwing you away. You can still do good things when you come out of prison. I'm not going to sentence you to 8 years in prison because you have done some things on probation, but I'm not continuing you on probation. So you're going to be found guilty. I'm going to revoke you. I'm going to give you credit for any time served. I'm going to suggest the therapeutic community. There's going to be no contact with Maria, Ahmed, and James Tristan. I'm going to order the removal of GPS because you're going to be in custody. They've asked for 8. I'm not sentencing him to 8 years. I'm not going to sentence him to the minimum. So what are you asking for?
Judge, I would ask for 3 to 4. He did make an effort. He has turned himself in the past, so he's not somebody who keeps absconding and not putting himself forward. Judge, he has followed all the rules. He could have run. He didn't run. When I went and talked with him this morning, we talked seriously about the fact that this may very well happen. And he didn't run, Judge. He didn't leave. I've had clients to just run out the door. He didn't do that. He still stood here to face. So although he made some bad decisions and he didn't handle things well, I think he has improved his life. And I understand that you may not believe that, but I've talked a lot with Alondra.
Oh, no, I believe he's improved his life.
Very, very stable. And so he hasn't been living under a bridge or using hard drugs or living off of other people, and he's been working. So I would ask, given that you give him 3 to 4 years, Judge.
All right, I'll sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
Because this is a plea bargain agreement, you have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. I hope you understand the reason why you're being sent to prison is because your actions. It's not because of the person you were with. At some point in time, we cannot just go off and live our lives and pretend like we're not on probation. And when you tell me I haven't picked up any new charges, there are a whole host of people in this courtroom who haven't picked up any new charges. When you tell me oh, I've stopped using drugs. There's a whole host of people who are abiding by the rules and not using drugs. The fact that you have not picked up any new charges, yeah, that's something I'll consider, but it's not the be all, the end all, because you shouldn't be picking up new charges anyway. So when you're released from the prison, I realize prison time is difficult time. Anytime you're locked up is difficult time, but you need to stay on the straight and narrow. If she ends up waiting for you, then she'll end up waiting for you. Make sure you don't bring any problems to her doorstep. Don't go to prison and get institutionalized. When you come out, if you feel like you're going to use drugs or you need help finding a place that could help you with any drug issues or whatever issues you may have, if I'm still here, you can come back and I'll make sure that you get that help. You understand?
Yes, Your Honor.
All right, good luck to you. Who's here? Are you already on Sergio Chavez? Okay.
Good morning, Your Honor.
Good morning. How's it going?
Pretty good. How are you?
Oh, all right. It's a
Nice to
beautiful,
meet you.
well, hey, it's pre-Friday.
That's right. Short week.
Yeah, we're so close. Yes. No, I don't. Oh, wait a minute. Yes, I did. I'm just waiting for them if they're ready.
Yeah.
Okay. All right, on this case, I know that Mr. Cabanas was recently appointed because Mr. Chavez is a Spanish speaker. Where are we on discovery?
Your Honor, my understanding right now was that defense was, had just conferred with immigration attorney and that they were waiting on PA letter.
Okay,
So, yes, Your Honor, to further explain, we have all the discovery videos and documents. We just met with the MAC immigration attorney for the second time because my client has a pending immigration process or immigration attorney.
Mhm.
And so he's in the process of giving me an explanation of what that process is like, so I could then forward it to the MAC immigration attorney. And then Padilla letter can be written.
okay. So when is this letter going to be written?
The Padilla letter,
Mhm.
as soon as his current immigration lawyer forwards me what that immigration petition is about, I'll forward it to the MAC attorney. So I'm hoping by next week, Judge.
All right. So this is going to be the last setting for immigration issues. I'm going to recall it for June 27th. Is that good for you?
Yes, Your Honor.
And once I give you the reset form, you're excused. Mr. Chavez, do you have any questions?
No.
All right, thank you. Once you sign the reset form, you're excused.
Judge.
You're welcome.
For your signature, Your Honor.
Oh, yes. You'll give it to the clerk and she'll pass it to me.
Yes. Maybe excuse Your Honor.
Yes, thank you.
Thank you.
All right, Marie Miles.
We're present, Your Honor. I've conferred with Zach and.
Oh, where's Miss Miles?
She's here.
All right, it should come forward.
Ms. Miles?
Yes, come forward. All right, where are we on discovery?
I think we're good on discovery.
Yes.
Were you able to tender an offer or no?
Well, we are of a slight, we're not entirely sure. Council believes that they have some information as to the potential cooperativeness of the complainant. We have other information. And so through conferring, we would like to kind of ensure that we both have a clear understanding on,
Of where the parties.
on where they stand.
Yeah.
All right, so council, you're going to be in town on June 20th?
Yes.
All right, so on June 20th, you all need to have worked that out. And on June 20th, state, you'll need to be prepared to tender an offer.
Oh,
Yes,
wait,
Judge.
wait, when is, okay, so when will you be back? I'll be back on the 26th. Can we, should be out of town with permission, I believe from pretrial already. Should be back after the 26th.
All right, the 27th?
Sure.
All right, we'll be back on June
Would that be
27th.
okay? Make it-
Thank you,
Yes.
Judge.
All
Thank
right,
you,
you're
Judge.
welcome. Once you sign the reset form, you're excused.
Okay, just have a seat. I'll bring you the receipt. Okay.
Yes.
I just realized we didn't. But that's all.
Oh, no, I put it in there.
Oh, you did? Okay.
Yes, and I said it. Yeah.
201, so thank you.
No, no problem. Thank you.
Thank you.
I'm gonna approach real quick.
Sure.
Called me yesterday on Victor Alvarez.
Yes.
That was like the letters.
Yes.
I came by on that today. He got a opinion for those.
Okay, let me,
But Sean, she's been in contact with the people at the jail to get word from PUC about whether or not he's actually rejected by safety. So they're still waiting on that.
Okay.
Try to bring him next week.
where's, let me have them pull the file and so I can write in there. Yes.
They didn't bring them over today.
Okay, yeah, have them, do they have the file on it?
I don't think so. Do you have a file on, there's, what's his name? Victor Alvarez. I don't think they do. No, she doesn't.
Okay, I'll go grab it.
All right, if you'll grab it and then I'll put a date in there. And what date? We can bring it over maybe June. But Sean, are you okay with bringing them over June 6th?
That's next week, Judge. I just need a few more days.
Oh,
so
no,
that I
no.
can get-
You want to do the 13th, the 20th?
No, no,
Right.
no. Next week will be fine.
Okay. So the 6th is Thursday. Or we can do it on Monday, Tuesday.
You want to do it on Tuesday?
All right, so I'll put it down for June 4th. Just have them pull the file so I can write it in there. You're welcome. Juan Tehran. Who's the prosecutor on Juan Tehran?
Mr. Zach Dunn?
All right, so this needs to be set for jury trial.
Yes, Judge. We agree.
Okay. And so I believe it was in impact court, but there was a continuance and now we're back here.
We're back here, Judge. But I do enjoy spending time with you, so I'm not upset.
And see, this is why I like for impact stuff that doesn't work out to be sent back here. Because otherwise we won't get a setting.
Mr. Fit on up and center.
So, let's see. All right, so this needs to be set on a day that it is going, because there will be no further continuances here. And I'm gonna send a notation to, if this goes to impact, I'm gonna send a notation to them that there's not to be any further continuances in this case. So, state, what are your dates?
In terms of which month, Your Honor, would you like to?
Let's see what's happening in July or June.
Or in impact July 1st, that month?
Okay,
Judge, I have vacation the 4th of July.
all right, June.
June, Judge, we are. I mean, we have a, would be too soon. We already have a full slate for the fourth, and then the next one is impact, that we have something.
All right, this is what I'm gonna do. We're gonna recall this case back. Everybody needs to be here at 9. We're gonna recall it back on June 3rd. On June 3rd, I'm giving you all a date, and that's when it's gonna be going to trial. Does everyone understand?
June 3rd, a date. Yes, Judge.
And I'm gonna give you a reset form. And then we'll be back. And on June 3rd, y'all need to confer on a date.
Okay.
And let me just tell you, no date past August. All right, once I give you the reset form, you are excused. All right, and who's here on Christopher Davis, I think? All right, if you all to come forward.
Judge, just, you know, they're not testifying, but we do have 3 people on Zoom.
Okay.
And 2 of them will get fixed back.
Okay. And that's that. And then after Christopher Davis, it's going to be Juan Casanova and Abel Martinez. Oh, you have to swear someone in? Okay. Who do you need to swear in? Oh.
Yeah.
Do you need the file on Pettis?
No, I don't.
Okay. All right, court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. I have parties announced for the record for the state. For the defense.
For Mr. Davis.
Suzanne Kramer also for Mr. Davis.
All right, Mr. Davis, you entered a plea on May 7th of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. You're coming open to the court. Have both parties had a chance to review the report from probation?
Yes, Judge.
Yes, Judge.
Any objection, state?
No, Your Honor.
Defense?
I have a couple of corrections, Judge.
Yes.
Regarding his discharge from the Navy, it was stated in there that it was less than honorable. I think his actual discharge was a general under, what's it called? Under honorable.
Okay.
General under honorable, not less than.
Okay.
And at the very end where he states a few things he wanted you to know, he referred to something that happened to him at age 5, but a subsequent conversation with his mother that was determined to have happened when he was at age 2.
Okay. All right, any witnesses?
Not from the state, Your Honor. We just have an argument.
Just Mr. Davis, Judge.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do have a couple other witnesses. Can we take them first, Judge?
Sure.
Thank you. I'm sorry.
All right, call your
Let's
first
call
witness.
Edith Davis.
All right, Edith Davis.
Stand over yours.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you're gonna need to keep your voice up so the court reporter can hear. Could you state your name for the record?
Edith Davis.
All right, defense.
All right. And Ms. Davis, are you Christopher's mother?
I am.
All right. And I think you may have heard me state just a minute ago about something that happened to Chris that you said happened at age 2.
Yes, sir.
And can you explain to the judge what happened and how that turned out?
So our babysitter was leaving. We were looking for a new sitter. My husband's getting ready to go to Korea. We found a lady that was in the neighborhood. She had 2 other children that were a little bit older. I had come early one day and found their children throwing rocks down on my children. Christopher was almost 3, not quite. Then when I got, found out she was giving them dog treats for cookies for their snack. And I had known that both my kids, Kristen was disabled, but Christopher, very active, gotten very, very afraid of when I was cleaning house. I didn't understand why, but when I had talked to my daughter, she's told me that the kids would take the vacuum cleaner and suck on Christopher with it and tell him that he was going to suck him up and he would suffer. So when I saw what was going on at the house, I immediately removed him from the house. I found my next door neighbor was going to take care of them for me. So it took a little while to get him a little bit more calmed down, but it was pretty traumatic for them.
And did you have a statement that you wanted to read for the judge?
I do. That's okay.
All right. State, do you have any objection to the reading of the statement or would
Sure,
y'all?
statement, Judge.
Well, I mean,
I know.
it's technically it's a narrative, but if you all want her to read from it or counsel, if you want me to read it,
I have no objections.
all right, you may proceed. That's okay. If it would, if you want to, I can actually read it.
Thank you, Judge.
All right, you're welcome. No problem. Just give me a moment. Thank you. All right, any further questions?
Do you have anything else you'd like to tell the judge? Okay, nothing from Ms. Davis.
All right, thank you.
I'm going to
Okay.
call Michael Davis.
All right, Michael Davis. Does anybody have any Kleenex?
I'm trying to get one, Judge. I can't reach.
Okay, thank you. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Davis.
All right, defense.
All right, Michael, are you Christopher's father?
Yes, sir.
We've had some conversation about this scenario and it's my understanding that you feel like maybe you could have done something different than would have avoided all this. Can you explain to the judge what you're feeling?
Yes, ADHD runs in our family. I was never diagnosed, but I've had issues with it my entire life. I'd learned to deal with it. When Christopher finished high school, he quit taking his medication. And when he joined the Navy, if I'd called the reservist office and told them that he was ADHD, because I know he didn't tell them, they would either rejected him or kept it, had him take his medication. His whole life would have been different. One phone call, if I'd made it, wouldn't be here. So, love my son. I know he did wrong, but that's all I've got, ma'am. I'm sorry.
No, I appreciate you coming in to testify.
I don't have anything further, Judge.
Any other questions?
No.
All right, thank you so much.
And Judge, at this point, I just have Mr. Davis.
All right, so raise your right hand for me. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Christopher Brent Davis.
All right, defense.
All right, Christopher, what is it that, other than what you already stated in the PSI, what is it that you would like the judge to know before she decides what your sentence ought to be? Your Honor, there is no explanation. There's no rhyme or reason. Nothing would be able to be justified as far as what my actions did. There's every day that I live with regret because it's not only one person I hurt several people, including my own children, my own biological children. The only thing I can ask is for forgiveness from them, and I will accept whatever consequence that you see as punishable, Your Honor. And Judge, this is the part where I do, like I tell my wife, if I tell you something from here on out and that you can accept it two ways, one to make you mad and one to make you not mad, I mean the one that makes you not mad. So, question that we have is what's appropriate punishment for this type of case for
All right,
Mr. Davis?
I'm sorry, just 1 second. State, you don't have any questions, do you? All right. All right, thank you for giving your testimony. And so the range of punishment for this offense is 5 to 99 years or life.
That's correct, Judge.
So State, what are you requesting?
Do you want my request and my argument or just my request? Right?
Your request.
You're asking for life, Your Honor.
All right. So they're asking for life. Defense, what are you going to be asking for?
Judge, we're asking for 20.
All right. So now, State, I understand why you're asking for life. Defense, I understand why you're asking for 20. So, one, I'm not going to sentence him to life. I've taken in consideration his testimony. I've taken in consideration the testimony from both his parents. And I want the parents to know, at some point in time in life, your actions are not the cause of your child's actions. Because how old are you?
38.
All right, so he's 38. At some point in our lives, when we're making our decisions, no matter what happened in our past that was horrible for us, or maybe our parents made a mistake in how they raised us, at some point, your actions are your own. All right, so I'm not going to sentence you to life, but I'm not sentencing him to 20. It's an egregious offense.
And if I may offer some perspective on that, Judge, that's what I
Yes.
intend to do. So we agree it's egregious offense. He agrees it's an egregious offense. It's something that went on for about 6 or 8 months from what we can tell from the stipulated evidence. And yet the same day that we were pending, that we actually entered our plea, there was another person pending who's had a death of a child, injury to a child causing death. And the very next day, this same prosecutor's office, same prosecutor.
I'm gonna object to this
offered
line of.
them 18 years.
All right, okay, so here's the thing. Defense attorneys, you all know that sometimes people can be at the Bexar County Jail or at the prison. Sometimes there are people at the prison for murder, they get 5 years. Somebody else at the prison for murder, they get 30 years. Every case is different, and there's a reason why people are given certain times. And there are reasons why sometimes this court follows a plea, sometimes that I do not follow the plea. Now, what I'm telling everybody, the state has asked for life. State can ask for whatever they want. I've already told the state, I'm not giving him life. So the argument about what they did in other cases, that's not an appropriate argument. We're here for this. Now, if somebody wants to make an argument that the same fact scenarios, as we would call it in law school, that the case is on all fours, if there's another case that's on all fours with this case, where the state gave somebody 12 years or 10 years, then we need some explanation, because maybe things are not being done fairly. So if you can present a case to the court that's on all fours with this case where the state made an offer of something less than life, I think it's relevant. I'll hear it, because maybe something else is happening in the office.
Well, Judge, and I would offer you something on that. I think it's on all fours. I don't know whether it's on all fingers and toes, but there was a case in the 227th where the fellow was charged with continuous sex abuse of a child, same as Mr. Davis. He was allowed to plead to aggravated sexual assault of a child, same as Mr. Davis, but he was given 12 years.
All right, so
for a 4-year-old child.
So let me ask you this. Was that a case where you had a defendant who's alleged to have pretended to be a juvenile online and then tricked his stepdaughter into allowing him to engage in sexual activities with her by pretending if she didn't, the new friend that the defendant had created, life would be in danger.
Of course, Judge, I cannot offer you that, but what it's, they just, for selective prosecution purposes and sentencing purposes, substantial similarity, I think, is what they look for. And in this case, you know, the same charge, same reduction, a 4-year-old instead of a 14-year-old. And this fellow gets 12 years and the state wants life. I know you said you're not giving that to them, but this guy gets 12 years in a different court. And Mr. Davis is looking at whatever that you choose to give him. So that's the only reason I'm offering that, Judge.
Right.
And again, back to the, I'm not trying to make you mad. I
No,
don't want to visit my sins on my client.
No. Here's the thing. One, I don't get mad. I believe that everybody should be allowed their argument. I've been a defense attorney before. People should be allowed their argument. I've been a prosecutor before. People should be allowed their argument. I don't get mad. And what I can tell everybody, when you're in jury trial, if this were a jury trial, guess what? Defense counsel's state's closing arguments, that's not evidence. Evidence is the steps that I have. Evidence is whatever testimony I receive. Closing arguments that counsel do on both sides, that's spin. And hopefully the arguments they're making is in some form or fashion connected to the case that was just heard. All right, is there anything else?
No, Judge, I would just like to highlight, there is one other statement from Christopher in the pre-investigation report at the very last page. It states that he was the subject of a grooming himself when he was around 12 years old by a 39-year-old. We've discussed this, and again, Judge, he's not of the opinion that it's any excuse for what happened, and he doesn't even really know if it lent any any substance or predisposition for him to have done this, but it's just offered for the court for contextual purposes.
All right. So I want to let you know that I heard all of the arguments. I internalized everything. And these are very difficult cases. Anytime someone comes open to the court, it's very difficult. And let me just tell you why it's difficult. This is the type of case where everybody will say automatically it's a life case, right? But I go on facts, I go on what I read, I go on everything. I go upon, experience I've had in dealing with specific cases. Because otherwise, if every case were a life case, then guess what? We don't even need to have a punishment hearing. It's just, this is what you did. We prove it, you get life automatically. So I look at everything. What you've done, of course, is something very bad. And people are going to be impacted for years to come, right? So sometimes when I consider what to sentence somebody to, I think about their age, I think about protecting of the public. And there are many things that I have to consider. Like, for example, is somebody going to allow you to be around children again? That's something I have to consider. Like, what age will you be where people will see you and they will not say, oh, that's a good catch. Let him babysit a child. Those are all things that I have to consider because part of my job is protecting the public. And I also have to consider evidence that's presented. I consider the stipulations that you stipulated to. So this is what the court is going to do. Court is finding you guilty. There's to be no contact with the complainant. There's to be no contact with any minor. There's to be Chapter 62 registration. Court is going to sentence you to 45 years. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
All
right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, we can go off the record. Here's the thing I want to let you know, just a second. I want to let you know that I appreciate the fact that you entered a plea to this, you entered a plea to it early, that when you came before the court, you didn't try to be wishy-washy on whether you did it or not. You are a person who truly took full responsibility for what you did. And I appreciate that you did that. All right, so can you mute us, please?
So Nova and then Kathleen are two impact.
Person here for victim impact?
Here.
Oh, yeah, that's our victim.
All right, you may proceed. And I'm going to stop your video.
Nova, unmute yourself, sweetie.
Judge, we heard from this witness at the date of the plea because they had flown them in from out of
Yes, but
state.
this is the victim impact. This is different.
All right, you may proceed. Excuse me.
Proceed
Yes.
with what?
Yes, you can put the camera for him.
Yeah, Nova, you can talk, sweetie.
All right, you may proceed.
Do I start reading?
Yes.
Yes.
Okay. Even after all you've done, after all of the activities you did and all the messed up things you did to our quote unquote family, I was able to fill myself with remorse, empathy, and sympathy for you. Now, don't twist it because I still hate your guts and wish you the rest of your life in prison. Also, don't be expecting forgiveness out of me. You might be able to convince other people, but you won't get it from me. You ruined a lot, but don't go raising your ego because you thought you ruined my entire life. You've only ruined things in it. You got away with it, or you've also improved my life. You got me away from you and Ashley. You brutally taught me how not to be so naive. You got the rest of my family away from you and Ashley and into a safer place. But most importantly, you found a way to wind yourself in prison. Here's a small list of all the things you've done to me, starting with the bad. You've made me relapse many times, gave me PTSD. You gave me a sleeping problem, suicidal thoughts, plus 4 different attempts, depression, anxiety, paranoia and trust issues, problems with talking about my feelings, nightmares constantly, fear of using any bathroom, gender questioning, panic attacks, caffeine addiction, slight smoking addictions, not being able to make friends easy due to trust issues, and problems with family members. Here's the list of good things you've done in my life. You put me into a position where I was being put with people who actually care for me enough to take Wyatt and I as their own children. That's it.
All right, thank you. Is there anyone else? All right, Ms. Davis?
Yes, Judge.
All right, you may proceed.
So I'm not sure where to start or the things to say to you, but this is where I'm going to start. Almost 16 years ago, when we got married, you said you would never hurt me or my daughter. who was only a couple months old at the time, or any kids in the future that we would have together. And I believed you. As our marriage went on, you ended up breaking that promise. You made me believe that I was crazy, and to the point to where I had to see doctors, therapists, and I didn't have friends anymore. I tried to help you be a better person, and it made you mad. I had no real warning about who you were. I'm glad I finally realized it with the help of some friends that I did make, and I made it out 7 years later. I made it out before things got so much worse than what they already were. Separated, divorced, went to court for our kids. You made people believe that I was doing things to our kids, and I wasn't. You played mental games with me and would verbally abuse me as well. After everything that you put me through, all the tears and the 7 years, you had everybody still believing that I was doing all of this. But eventually, you were caught because you did it. Sorry. I've been angry, yelled, screamed, cried over everything, and I blame myself for it, for not being able to protect our kids. You're not half the person I thought you were. But after all these years, I realized that your actions say more about your character than they do about me. I hope that life gives you everything that you deserve and you live peacefully with your choices that you've made, because our children and I won't be losing sleep over you anymore. You are where you belong. I feel you not only need for me to apologize for things that you did to me, but to the rest of my family and to these kids. And I hope that you pray hard for that and that one day they can forgive you. But I also want to sit here and say thank you in a roundabout way, Chris, for everything that you've put me through, but because you've not only made me a stronger woman, but you've made me a stronger mother when it comes to protection of our kids. The kids have decided that they wanted to say something to you. Our daughter states that, to me, you were never really my father, only because you treated me like I was nothing, for always lying and never listening when I told you the truth, for robbing me of my childhood and making me have to grow up too quickly.
All right, excuse me. I'm so sorry. The defense has raised an objection. I'm going to sustain that objection. Thank you so
Okay.
much for coming in to give your statements.
Thank you.
All right, thank you. All right, thank you. All right, Amber Salazar. State, have you tendered all discovery? It's a direct case. Do you have all the discovery?
Everything that's uploaded, Judge, it's first setting. So we have we conferred, and I believe I have all the discovery.
All right, so we'll come back on June 27th. On June 27th, states you need to be prepared to tender an offer.
Yes, Judge, and defense did bring up an issue for me to look into, so that's kind of why.
All right, is that enough time?
Yes.
I think that's.
All right, once she signs the reset form, you're excused.
Thank you, Judge.
You're welcome. Thank you. Thank you. Thank you for dressing appropriately. John Alberto Casanova Paez.
Morning, Judge.
Morning. Hello. So on this case, we're going to come back on June 3rd. On June 3rd, you all going to get your jury trial date.
Okay.
All right, so let me give you a reset form. And once you sign that, you will be excused. All right, is there any other outstanding issues that need to be discussed?
No, ma'am.
All right, so we'll come back on June 3rd. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Do you have the reset form there?
Yes.
Okay. Thank you.
You're welcome.
Yeah, Renee has one case, Parker has like 3 years before.
Who's here on Abel Martinez?
Then.
Abel Martinez? Oh, sure. Okay. State, are you ready on this restitution hearing?
Okay, I'm ready.
Okay. All right. So, just give us 2 more minutes.
Okay, Jen.
Zion Taylor. Who's the attorney for Zion? All right, thank you. Yes. Everyone, the court is recessing at 12. And you have to come back in the afternoon. Hi, so you have all the discovery. Has the state been able to tender an offer?
They have, Judge, and they're finished their discovery issue. An issue came up today on our end that I need to investigate. Actually, a couple of issues that I need to investigate that have to do with some research that's gonna have to be done and some investigation.
Okay. Let me see here. All right, I'm calling you back on July 8th. That is going to be your plea deadline date. So any investigation that you need to do will have to be done by that date. Is that enough time?
I would hope so, Judge. If not, I'll file a continuance and advise the court.
Okay. All right, once you sign the reset form, you're excused. And Mr. Taylor, you need to make sure that you're on time for court. You understand?
Yes, ma'am. Thank you. Just maybe excuse.
Once he signs the reset form.
Wait
We're
for
just
just one of
waiting.
my case.
You're good. Oh, yeah, I get it.
All right, who is here on Michael Pettis? Michael Anthony Pettis? Court is calling 2024 CR 0254, State of Texas versus Michael Anthony Pettis. Could I have parties announced for the record for the state?
Daniel Escobar, State of Texas.
Defense?
Freeman Martinez.
Are you Mr. Pettis?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Do Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1, intox manslaughter, and count 4, aggravated assault with deadly weapon, and we're waiving count 2 and count 3.
No objection, Judge.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
All right, off the record. So state and defense, if y'all will write here that the intoxication manslaughter is count 1, and then just do a comma, count 2, aggravated assault with a deadly weapon. So,
Yes, Judge.
Okay.
Sorry about that.
oh, no problem. So did you understand in count 1, you're charged with intoxication manslaughter, and count 4, you're charged with aggravated assault with a deadly weapon? Those are 2nd-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine in each count. Did you understand?
Yes, Judge.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand by entering this plea, you were giving up those rights?
Yes, Judge.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Judge.
Counselor, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Has anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
Are you a U.S. citizen?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Off the record for a moment. This is attached to the court's file.
Was it a CD here?
Yes.
It should be. Yes, Judge, that should have been in the stipulation.
Okay. All right, we're back on the record. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, you're to plead to counts 1 and count 4. Punishment is to be assessed at 12 years in the prison. There are no applications. And if you are not present for sentencing, you're subject to the full range of punishment. Did you understand that would mean that if you do not appear, then your plea would stand and the court could sentence you to the full 20 years? And that would still be a part of your plea bargain agreement. Did you understand?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Judge, the only thing I didn't hear you mention was the affirmative finding of a deadly weapon.
Yes, there's an affirmative finding of deadly weapon. Did you understand?
Yes, Judge.
Defense?
Yes.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No comment.
Count 4, how do you plead? Guilty, not guilty, or no contest?
No comment.
State any evidence.
State offer states exhibit 1 and all attachments.
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty in count 1. Court will find you guilty in count 2. I'm sorry, count 4. And the court will find there is an aggravated, there is an affirmative finding of deadly weapon. And you are requesting that sentencing be at a different date, counsel?
Yes, Judge. What I'd like to point out to the court, even though it looks like this is a really old case, it just got indicted this year, 2024. We had a plea deadline very recently. We finally got a plea offer. We reached a resolution fairly quickly for a case of this nature. And I'm telling you all that so that you would understand my client didn't have a whole lot of time to start getting his affairs in order. He totally understands the admonishments in the plea agreement. He's single. He needs to dispose of his assets. He needs to leave property with his family. He's been self-employed for many years, and so he's closing down the business. So there's a lot of things that have to be done. We're asking for a date in July, Judge.
All right, I'll give you July 27th. We'll see where we are at that point in time.
Perfect.
All right, is there anything else from either side?
Very well.
All right, once you sign the reset form, you are excused. Oh, no problem. I was like, oh my gosh, what am I supposed to do with this?
Hi.
Do not invite anyone. I don't talk to anyone. They will approve loans.
All right, and Suzanne, whenever you're ready for yours, State, are you ready on Abel Martinez? All right, sure. Brandon Diaz.
Morning, Your Honor.
Good morning.
We have a note from, I have a note from the advocate that she was given a date for CPS records. They told her June
Mhm.
26th.
I'm sorry, when?
June 26th.
All right. So what we'll do is we'll recall this for June 27th for CPS records.
Thank you, Judge.
Let me just find him on the docket. Hmm. Am I missing? Do you see what page he is on the docket?
Brandon Diaz?
Yes. All right. Thank you. All right, why don't you sign the reset form? You're excused. Thanks for dressing appropriately for court.
Thank you, Judge. Judge, while I'm
Welcome.
up here, I have a quick announcement on another case.
Who?
Gilbert DeLeon.
Have them pull the file.
Okay.
And sir, if you go take your seat.
Judge, if I could jump in just for 1 second.
Yes.
I think you told us July 27th, but you wrote.
Oh, no,
27th.
June 27th. It's
Okay.
June 27th. I'm sorry. And then we'll see what happens at that date. Gilbert DeLeon. All right, where are we on discovery?
Discovery, I think we're in good shape, Judge. The real kind of crux for this case is complainant was a fugitive with their own pending case, and I think they've come back to join us. And so we'd like a small update to see kind of where we're at with them with regards to this case, Judge.
All right.
We shouldn't need much.
How much time are you asking for?
2 weeks.
That's fine by me.
All right. And this will be the last date for you all to get in touch with your complainant. So I will set it for June 17th. Once you sign the reset form, you're excused.
Thank you, Judge. We appreciate it.
All right, you're welcome.
Thank you, Judge.
You're welcome. Travis Mann. All right, good morning. This is Criminal Trial Division. Have you received all the discovery?
No, Judge, I tried to download it or review it, but it's down.
It's been done for a while. You tried to get
Oh,
on
because
it.
they're doing
Something.
something with
So you
the,
try to get it and it doesn't upload the page. And sometimes it does, but it's getting very difficult. And there's a bunch of videos on this case.
all right, we're gonna recall it on June 13th for discovery. Once your client signs the reset form, he can be excused.
Thank you, Judge.
You're welcome. Thank you.
That's.
Renee, Hernandez. Renee Hernandez. All right,
Neither is Mr. Parker's.
okay.
Need them. I know.
All right, who's here on Tyrese Jackson?
I am, Your Honor, ready.
Tyrese Jackson.
Court is calling 2020 CR 5704B, State of Texas versus Tyrese Jackson. Can I have parties announced for the record for the state? Defense?
Sharon Thorne, the defendant.
Are you Mr. Jackson?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Tyrese Jackson who was placed on deferred adjudication in 2020 CR 5704B for the offense of robbery on July 27, 2020 for a period of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violate condition number 2, on or about the 11th day of April 2024, Door County, Texas, the defendant Therese Lorraine Jackson did then and there illegally use a controlled substance, namely methamphetamine, violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
We'll waive the remaining violated conditions, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty and sentence you up to 20 years in prison? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement? Yes.
It is to grant the motion to adjudicate and revoke the individual and assess 4 years of the Texas Department of Corrections.
Is that the agreement?
That is the agreement, Your Honor, and in conferring with the probation, I discovered that he has 859 days credit and he has 275 days credit for safety. And I am requesting of this court that you grant him all those back time, including the safety time.
Did he successfully complete safety?
Yes, ma'am.
Yes, Judge.
All right. Then the court will find violation of condition number 2. The court will find you guilty. The court will grant the motion. The court will sentence you to 4 years in the prison, give you credit for any time served, and I'll give you credit for the time you spent in safety. I'll request the therapeutic community.
Excuse me, before it's time for me to walk up, is it okay for me to speak to you?
Okay, just 1 second. So I'll give you credit for any time served. I'll sentence you to the therapeutic community, and I'll give you credit for any inpatient treatment time. Is there anything you wish to say?
No, the last time we spoke was when we was at the graduation at drug court. I apologize for not succeeding like I told you I would. I had a falling out. I found out my oldest daughter wasn't mine and I fell. I couldn't cope. I couldn't hold in my feelings and, you know, I do want to apologize because I know you have faith in me.
Okay, I appreciate your apology, but you're gonna have to start doing better. Otherwise, you're gonna find yourself in and out of prison. When you're released from prison, this drug problem will still be there, so you need to take care of it. When you're released, if you can't find some place to go, if you come back here and I'm still here, I'll direct you to a place. You understand?
No.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Honor.
You're welcome. All right, who's here on Elazar Alejandra?
Here, Your Honor.
All right, if you'll tell them all to come in, please. Thank you. All right, State, on this case, were you able to tender an offer?
Yes, Your Honor. Offer has been, which cause number is this, Judge?
This is 11510B.
Bravo, offer was given to Mr. Delprado.
All right, so your plea deadline date is going to be June 27th. At that point, you'll need to let the court know whether or not you're accepting the offer that has been tendered. If you all are not able to work out an agreement, then you will be given your jury trial date. Does everyone understand?
Yes, Your Honor.
All right. One day, I promise I will learn how to pronounce your first name.
It's fine, Your Honor. This is your courthouse.
No, as they say, it's the people's courtroom. All right. So that will be your plea deadline date. All right, once you sign the reset form, you're excused.
Awesome.
And thank you for always dressing appropriately for court.
Thank you, Your Honor.
All right. Nathaniel Villalobos. All right, good morning. And State, were you able to tender an offer?
Yes, Your Honor. An offer has been extended to Mr. Norton.
That is correct, Your Honor.
All right, your plea deadline date is going to be June 27th. At that time, you need to let the court know whether you all have come to an agreement. If you don't come to an agreement, your next setting will be a jury trial date. Does everyone understand?
Yes, ma'am. Sure.
Yes, ma'am.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court, as always.
Then Judge, Mr. Escobar is back in the courtroom.
Okay, just give me one moment. Flores. Alfred Flores. Hello, good morning. All right, so you're going to come back. State, were you able to tender an offer?
Yes, Your Honor. An offer has been extended to Mr. Nesbitt.
All right, your plea deadline date is going to be June 27th. On that date, you need to let the court know whether you all have an agreement. If you don't come to an agreement, then you will have your jury trial date as your next setting. Does everyone understand?
Yes, Your Honor.
Yes, ma'am.
All right. Once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. Thank you for dressing appropriately for court.
Your Honor, may the state be excused.
Yes.
We have Mr. Hernandez in the box, Judge.
All right. Brian Parker.
They haven't brought him yet, but they brought Mr. Hernandez.
Okay. All right. Renee Hernandez. All right, and so this case, I'm looking at the docket. There are a lot of cases.
We have plea agreement,
Oh,
Judge, but we can't do paperwork.
ah,
So I think if we just, I don't know when we're gonna be,
all right, so what I'll do is I will recall it.
it's for time anyway, so it's not like it's.
He'll have to do another couple and a half weeks, Judge, and I'll be out. I can certainly appear by Zoom, but I'll be out next week, out of town, that is. If we can do it the old Zoom way, that'd be fine. But
All right, I don't know, do y'all want to do it by Zoom?
Well, Judge, I mean. I
Because
don't know
it will
if-
be difficult because still need to do the
Right.
paperwork.
If we can set it off until Bob comes back,
All
I
right,
think that should be better.
when will you be back?
the week of the 10th, Judge.
All right, so you all want to set this for. Let me see. You want to set it for June 11th?
We can do that, Judge. Is Monday not available?
Oh, no, we can do it on the 10th, but sometimes when people are coming back on a
Yeah.
specific day, but you want to do it on the 10th?
No, the 11th is fine. You're right about that. That's
All right,
giving
so
data.
we'll be back on June 11th for disposition.
Thank you, Judge.
You're welcome. Deputy Laura, he can go back.
And focus on his way.
Mhm. Are you all ready on Abel Martinez?
Have a seat. Mr. Hernandez, have a seat over there. And do not talk to him.
Are we really not gonna be able to do please till the system comes back up?
Oh, yes, that you can tell there was great
And not
planning
just-
that went into this.
That doesn't make any sense at all.
All right, court is calling 2023 CR 11529, State of Texas versus Abel Martinez. Can I have parties announced for the record for the state
Daniel is for the state of Texas.
defense?
Hey, Dan Kramer.
Are you Mr. Martinez?
Yes, ma'am.
All right, the reason why you were appointed an attorney is because the court received a report that there's a request for restitution. And I wanted to make sure that you had an attorney for this hearing. Ms. Kramer, are you prepared to proceed?
Based on the information that I was provided, it seems fairly simple, so yes, I'm ready to go.
All right, state.
Your Honor, just from the information that we were able to get, my understanding is that the complainant was stating that there was $1,000 that was in the vehicle, whatever, verbally, and that we never got restitution back for that. In addition, my understanding is that there were amounts that weren't covered by his policy with employer's insurance. The complainant, as it appears to the state, did submit paperwork showing the withdrawal of money from the ATM back.
I'm sorry, didn't hear you.
Sorry, the complainant did submit paperwork showing that there was a withdrawal of money in the amount of $1,000 on that date. And at least according to the state, from reading the police reports, it does indicate that he did complain about his own fee. This isn't a new thing that he brought up.
All right, any objection to the court reviewing the documentation?
Not at all, Judge.
All right, so the court is reviewing the documentation and it shows that there was a transaction, an ATM withdrawal on August 17th at 17:02 for $500 and another withdrawal from the ATM on August 17th at 17:03. Both of those withdrawal amounts, I'm sorry, were $500 each. And what is does anyone know the alleged time that this offense occurred from the stipulations?
I just have the supplemental, so that would have to come from the state.
If there are no objections, I'm looking at the supplemental. And the supplemental, they have August 17th as the offense date. And in the stipulations, it says the occurrence of the event was 1845 with end time of 1935. So,
On the same day?
yes.
But that, what is that, like 6:30 to 7:30?
Well, the complainant is showing a withdrawal from the ATM on August 17th at 17:03.
And that's
And-
like 7 o'clock?
That's 5.
PM? Okay.
Yeah. And then the incident, according to what's in the STIPS, it has August 17th. And the time frame is 18:45, which would be 6:45. And the end time is 19:35. Yes,
Okay, and Judge, if my turn? I don't know if it's-
yes.
As far as the supplemental, I think it says 1,200. In any event, I mean, circumstantially, we don't have any real proof that this money was in the glove box. Anybody could basically, say, oh, I want this money, I put it in the glove box, and, we don't have any idea if it was taken or not. I would think that there should be more than just some, I don't know, unsworn statements from them that this money was in the glove box, alleging that he took it. Secondly, as to the proof from that the insurance company didn't cover the window replacement of 450, documentation of that would be nice. I haven't seen anything like that where the insurance company did not cover that. So barring that, I would say that the court should, at least not at this point, order the payment of the 450 either.
All right. So with regards to the $1,000, which is the ATM withdrawal of 2 ATM withdrawals, $500 each, the court is going to order the restitution for the $1,000 for the ATM withdrawals. With regards to your argument about what the insurance did not cover, do you have any proof of that?
Judge, I could look at discovery right now. I just didn't have a moment.
Okay.
But I would ask if the complainant does have time just to prove that. That seems like something you should be able to provide.
All right. If he is able to provide that, then the court will hear any arguments for why the court should not consider it counsel.
And so at this point, it's not ordered and we'll have to have another restitution if it gets provided.
Yes.
Thank you, Judge.
All right. So you're going to be ordered to pay the $1,000 restitution to the complainant. Do you understand?
Yes, ma'am.
All right. Is there anything else?
No, Judge.
All right.
Thank you,
Thank you,
maybe
Ms. Kramer. Yes. And Ms. Kramer, make sure that you receive the appointment order.
Yes, I don't think.
If you
Norman's
can come
not here
back
yet
this
on that.
afternoon.
Okay.
All right. Thank you. All right. Is Brian Parker here?
Yes, Judge.
Are you all ready?
Yeah, Judge. It's very similar to the other case. So
Okay.
there's gonna be a plea.
All right. So we can set this on the same date, June 11th.
Yes, Judge.
All right. We'll recall it for June 11th. All right. Thank you.
You want to just take a seat again?
Yes.
Thank you.
Jose Sanchez.
Morning, Judge.
Good morning. All right, so where are we on discovery?
Well, Judge, I think this is a similar case. We agreed to a plea agreement. And I just need a reset for that.
All right, we'll come back on June 11th. Is that good for you?
Yeah.
Or do you want it sooner?
No, June 11th should be fine.
All right, so I'll give you a reset form, then you're excused.
Okay, perfect. Thank you, Judge.
You're welcome.
Thank you.
Yes.
Here you go. I may need to hire you for all the spam calls that I receive. I may want to hire you for that, to stop them from calling.
I can tell you this, iPhones right now are such a bad thing for me because of, like, I lost my iPhone in my own house on Sunday night, in my own house with a dead battery. And I have a replacement one that doesn't have enough memory. So I keep getting stuff that I don't even know what it is. Even this morning, like I'm getting like calls and texts and I don't know what it is.
Yeah.
So-
Okay. All right, so everyone, we're going to take